SJC-12141, Lynn, Blanchard, and others, v. Steward, Carney Hospital, and another.
Good morning, Mr. Dretler. When you're set, we're ready for you.
Thank you, Your Honor. Good morning. May it please the court, Jeff Dretler for the appellants Steward, Carney Hospital entities and its former CEO, William Walczak. Your Honor, this case presents the issue of whether the anti-SLAPP statute protects statements made by the CEO of a hospital which appeared in the Boston Globe and in an email to hospital employees in the midst of a major crisis when government agencies, the Department of Mental Health and the Department of Public Health, were threatening to shut down a unit of the hospital and revoke its license to operate. We believe the lower court erred in two ways. First, by failing to find that when looked at in context, Mr. Walczak's statements were made in connection with an issue under review by a government agency, and by failing to find that the statements made by Walczak were, quote, mirror images of statements in the Harshbarger report, which the lower court found was itself protected activity.
Let me just stop you there. With respect to your first point, that they were on an issue that was before, I mean, is that enough? Put the mirror image to one side for a second. You think that's enough? Just that it's on an issue that's before a governmental agency?
Not every statement that's made on an issue before a government agency is protected. So the statements must be made in connection with and in furtherance of the petitioning activity.
Okay, yeah, I mean, because all you said was an issue, and it seems to me that couldn't be enough, just that you have.
Well, the test under the statutory language says in connection with an issue under review. The case law then discusses what that means. What does in connection with means? And for example, in the Global Naps case, the court there found that a statement made by the spokesperson for Verizon to the media after an arbitration had occurred and while it was still on appeal, that a statement made to a gratuitous statement there that the arbitration had shown that Global Naps was engaged in a scam was not in furtherance of the petitioning activity because it couldn't have been deemed in any way to have been intended to reach decision makers. In that case, you've got a court reviewing an arbitration decision. Whatever's in the press has nothing to do with it. That's very different.
Or so you hope.
That's my argument, that that's very different. And there are numerous cases, this court and the appeals court have decided where statements made outside of any formal governmental proceeding can constitute petitioning activity.
Can constitute it. I mean, it doesn't have to be solely, that petitioning activity has to be solely the reason that the suit was brought.
The sole basis test, Your Honor, respectfully, the sole basis test, which was developed in Duracraft and other cases to ensure the constitutionality of the statute, the focus is on the claim, the sole basis of the claim. The focus is looking at the plaintiff's claim, not at the petitioning activity. The fact that petitioning activity, well, I mean, once it's deemed, excuse me, the statements.
I thought it was the sole basis for the petitioning activity.
No, it's the sole basis of the claim. Does the claim have a basis other than or in addition to the petitioning activity?
How did the email in any way seek to influence DMH when it was an email sent to employees to justify layoffs?
The email looked at in context served the same purpose as the statements to the press. The email was sent on May 27th, the day after the terminations occurred.
But it was never sent to the regulators.
It was sent, right, it was sent to employees saying, we just fired all these people for these reasons.
It said that, and it said more. It said, first of all, looked at in context, the regulators were on site and had been on site off and on since April when the incidents were first reported, and they continued to be on site through August when they finally made the decision to renew the license. There's testimony.
It was an email to employees. The email did not go to DMH, correct?
Correct. The
It wasn't
email did not go to
CC'd.
DMH, but the email the email was not simply, yes, it was directed to employees, but it was more than just a report on the remedial action that was being taken. It was, in fact, a statement, a declaration by the hospital CEO that these are the standards that the hospital finds are important. This is what we're going to do going forward, and I want, to make that known.
But it's, if they don't send it to DMH, are we supposed to infer that employees are going to show it to the people who are wandering around the premises?
I think in this case, it's a reasonable inference because the regulators, I'll grant you, it's a tougher question than the media statements. But in context, the regulators weren't just, wandering around. They're interviewing people in close touch. And I'll point out that in the Boston Globe article, for example, the May 28th article, there's a report about a letter that the union sent to these very same hospital employees, the nurses, on almost the same day, explaining what their position was, and somehow that got to the Globe. So
if you had said what they said is defamatory to the good name of the hospital, that would be excluded under the that would fall within the anti-SLAPP? Because
no,
they,
Your Honor,
because they are trying
weren't
to influence?
petitioning. I'm sorry.
Okay, well, here's sort of the problem. The anti-SLAPP, the rules need to be clear enough that a plaintiff needs to know whether it's going to be inside or outside the anti-SLAPP, because the consequence of it may be that they have to pay your attorney's fees, which I expect will be a fair chunk of money if you prevail. So you're saying that before they filed this defamation claim with regard to the email, they should have understood that the email was part of an overall plan by the hospital to save the unit from being removed from either Medicaid or Medicare funding, and that they should have understood before they filed that this would be petitioning activity because of the hospital's efforts to influence the agency?
Your Honor, I certainly understand the concern that plaintiffs ought to have fair notice before filing a lawsuit for which they could be subject to fees. But in all of the cases decided in the last 20-some-odd years, whether or not the plaintiffs reasonably would have known that their lawsuits would have been subject to the anti-SLAPP statute has not been a factor.
Well, that may be, but tell me, but of course, we would want there to be clarity.
Yeah, absolutely.
Okay, so tell me what the clear rule that you suggest would say. How do you win? What is the standard that we set that would permit you to win, which would provide clarity to another plaintiff who is considering a defamation claim?
Well, the standard, I believe, is already set forth in the cases, and I'll grant you, Your Honor, that it is not.
Articulate for me.
The standard
Excuse
is-
my ignorance, but articulate what would be the clear standard that would make it clear to them that by suing you on the email, they are within the realm of anti-SLAPP and may now themselves be slapped with attorney's fees.
The standard, Your Honor, would be that statements made concerning an issue under review by a government agency, and where those statements are in furtherance of the consideration by the agency of that issue.
But
And in
how,
this,
go ahead.
I'm sorry, in this case, it was well known that the agencies were investigating the patient abuse incidents that had been reported in April, and that they were very seriously considering revoking the license of the hospital to operate that unit. They had immediately stopped the census and reduced the number of patients. They were looking, the agencies were actively looking for evidence that the hospital was taking steps to be sure that patient care would be paramount, and to file a defamation lawsuit after they already had filed grievances through the arbitration, that the fact of the termination is already being, and whether that was pursuant to the collective bargaining agreement or not, is already being decided in another forum. But to sue on defamation about statements that were made in the midst of a public discourse on
It doesn't
patient
matter
safety.
who the statements were made to? That doesn't matter at all? These were
Yes, Your Honor, it
statements
does matter.
made to fellow employees, other people working at the hospital, right?
Absolutely,
Not
Your
to
Honor.
anybody else expressly.
Absolutely.
So you don't,
If
they'd
the-
have to imagine that somehow these statements were intended really for a DMH, not for the people that they were expressly.
Well, we don't have to, Your Honor, there is evidence in the record where CEO Walczak states in his affidavit that was his intention. There's no
So
contrary
they have
evidence.
to read his mind?
No, Your Honor, he's stated his intention, and there's no contrary evidence other than to whom the email was addressed.
He stated his intention after there'd been a lawsuit, and he was asked to file an affidavit. But Chief Justice Gantz is asking, how's the plaintiff going to be able to calibrate whether to file a lawsuit when they're looking at internal emails, and then they have to decide, gee, are these internal emails part of the response to the regulators so that we can achieve our goals? That's a pretty difficult position for plaintiff's counsel to be in.
It is, Your Honor, and I'll grant that the test that's been applied over the last 20-some-odd years in all the cases, some of them are difficult to tell in advance whether statements are going to be deemed to be petitioning or not, because it's quite clear when statements are made directly to the government agency that those are going to be protected. But the statute and case law provides protection beyond that, and it provides that statements even made attendant to that direct communication, when looked at in context, can reasonably be deemed to be in furtherance of the petitioning act of the issue under review.
But, you know, it sort of turns anti-SLAPP on its head, is that at one point it was thought that the purpose of the law was to protect the little guy who was going to be threatened with a defamation suit by the rich developer or whatever else. And now the danger is that the little guy, and you may dispute whether the union's a little guy or not, but let's, for the sake of argument, the little guy now has to worry that the hospital is going to be able to make an argument which is going to impose upon the union the burden of paying attorney's fees because they don't understand the overall strategy of the hospital with regard to its agency internal investigation. I mean, that's, it would arguably mean that the big guy can basically say, I'm going to make an argument that will say this falls within petitioning activity, and you're going to have to pay the fees that I paid to a big fancy law firm, and it's going to bankrupt you.
It's true, Your Honor, that the statute and legislative history shows that the statute was enacted to be in response to a very specific concern that you described. But Governor Weld tried to narrow the definition, and that was rejected by the legislatures. And Duracraft makes clear that the statute, that petitioning activity is to be read broadly. And if you look at the cases,
But if you look at Coburn, it's narrowed by whether or not it's seeking a redress of grievances.
Coburn looks at who is seeking the redress
Well,
of
that's
grievances.
not all Coburn is looking at.
You know, whether it's the government petitioning itself or someone petitioning on behalf of an entity that's actually
me ask
seeking
you-
redress. If I could just point out one thing, in Office 1, for example, versus Lopez, you've got that very same argument was made to this court by that the trustees, Office 1 wanted to open up, buy condos in a certain building, and the trustees of the condo did not want that to happen because they viewed it as an unsavory telephone sex business that was going to happen on their premises. And the argument was specifically made that the statute was not designed for wealthy, politically well-heeled movements to dismiss, and the court rejected that.
Could I ask you a question before your time expires about attorney's fees? As I understand it, you're asking that you be awarded attorney's fees because you prevailed on part of the defamation claim. I always understood that attorney's fees would be appropriate if the defendant is out of the case altogether. That's not the case here. You're still in the case. You did not succeed in getting the case dismissed because what you did is solely petitioning activity. So I don't understand how you get to attorney's fees if the reason for attorney's fees doesn't apply in this case.
Well, Your Honor, respectfully, the cases by this court and the appeals court have made clear that attorney's fees are appropriate when any claim is dismissed pursuant to the anti-SLAPP statute.
But it's the defamation claim has not been dismissed.
The other cases that have preceded this one have admittedly focused on counts where, for example, an abusive process or malicious prosecution claim where 2 out of 3, let's say you got abusive process, malicious prosecution, defamation, and 93A, and a court might dismiss on an anti-SLAPP grounds 2 out of the 3 or 3 out of the 4 and leave the 93A. This court has still, even where all the claims are against the same defendant, the defendant is not dismissed, there's still a fee award appropriate, and there has not been any case that has ever discussed the issue of when there are 2 separate.
But your motion only relates to this particular claim, right? The defamation claim.
Yes, Your Honor, and as the appeals court pointed out, in this circumstance, there are 2 separate predicates for the defamation claim. There's the email and the Globe articles, and the appeals court said that they could have been split into 2. And as I've cited in my brief, persuasive, I think, language from the California appeals court addressing this very issue where they say if that is the case, if the standard is that the whole claim must be dismissed, plaintiffs, and I'm not saying these plaintiffs intentionally did this, but plaintiffs could plead around the attorney's fees by always including a non-petitioning activity.
It's just different evidence for the same claim. One is the email and one is the statements to the Boston Globe, but it's still defamation.
It's 2 separate instances of defamation. One is to staff and who heard that, and one is to the public at large.
But as it stands now, you still have to defend the defamation claims. So how is it that you're entitled to fees if you're still in the case?
Defending a defamation claim where, from an email that, as your honors have pointed out, went only to employees is a different claim than defending a defamation claim about statements that were in the Boston Globe.
But if you're right, it would only be marginal cost. It would be what's the marginal cost to you of having to defend both as opposed to one?
Correct. I would advocate for the same kind of lodestar type analysis that occurs in any case. If you have a Chapter 150.
But it's the margin.
Yes, not the whole.
It's a difference between what the cost would have been to you had you only had to defend against, say, the email claim and not both claims.
Precisely.
Okay, thank you.
Thank you.
Good morning, Your Honors. I'm Dahlia Radovsky. With me is Ellen Messing, and we represent the 9 nurses, 8 of whom are here today. Not the union, by the way, just these individual nurses.
Thank you.
The union is not
I
a
stand
party.
corrected, thank you.
I'd like to make 5 points. First, and I'll summarize them and hope to get through them. First, Steward fails to meet its burden under Duracraft versus Holmes Products Corporation of showing that Mr. Walczak's statements served only a petitioning purpose and that the nurse's claim has no substantial basis other than Steward's petitioning.
So you're saying they didn't meet their initial threshold burden?
That's right. They do not meet it because, as the record shows, and as I will cite, Mr. Walczak admitted a non-petitioning purpose as to each of his statements. As to the email statement, he admitted a labor relations workplace interest purpose. He was warning employees, we had cause to fire these people and you all better shape up or we'll fire you too. That's in the record.
Duracraft is that the threshold showing that quote, that the claims against it are based on the petitioning activities alone and have no substantial basis other than or in addition to the petitioning activities. So how is
Correct.
what you say different from what your brother counsel just said?
The defamation claims are not based on the petitioning activities. They're based on an email to workers that had a labor relations nexus and purpose, and the email is silent, utterly silent about any petitioning.
So that's as to the emails.
That's as to the email. The Globe, there is an admission there too, that the reason that he wanted to communicate to the general public, as well as to the regulators, why he fired these people, and also what assurances the hospital could give them that their patients would be given safe and competent care. So in other words, that purpose is not a petitioning purpose either. That's public
Petitioning
relations.
purpose, or is it a petitioning activity?
The petitioning activity is nowhere in any of those Globe articles. If your honors will read those articles, which are in the record, and I can give you the page numbers, there is no mention in either of the Globe articles of any petitioning before the DMH.
Are you saying, though, if the, you've got what you would say, I'm talking now about the Globe. So you say it had two purposes, right?
Yes,
Both the regulators and the general public.
yes.
And you say, as long as it wasn't just the regulators, even though it may be, it cannot qualify. That's what you're saying.
That's exactly what Duracraft states. In Duracraft, if I may remind the court, what was at issue was some deposition testimony. The same utterances were deemed to have two purposes. One was to further the lawsuit in which the deposition was taken, but the second purpose, which was the or the second character of those remarks, was that it breached a non-disclosure agreement. So the very same words were deemed to have a dual character, and therefore the anti-SLAPP motion was denied, and and Duracraft was permitted to proceed on its claim.
So, I'll ask you the inverse or the converse or whatever of the question I asked your brother. So you have an environmental group protesting a major development which needs regulatory approval. They write a letter to the regulator saying that all sorts of reasons with regard to this development, including the motivations of the developers, and then they speak to the Boston Globe and they say, we just wrote a letter to the developer and we said all of this. And the claim is, well, that's not a sole purpose because that also was trying to get the public to oppose this as well, and that's not a petitioning purpose, and therefore we can sue those people without being confined to SLAPP.
Well, that is not this case.
I understand, but this idea that when you speak to the press about something, that even if you say essentially the same thing, it falls outside of it, means that you're going to be telling protest groups, don't speak to the press, only speak to the petitioning agency because you lose your protection under anti-SLAPP.
No, I think, Your Honor, this case is very distinguishable on the facts. There's nothing about the petitioning in the Globe articles. It's about labor relations and public relations. It doesn't say anything about go tell the DMH this or go support us at DMH. It's silent about DMH.
Well, who gets to decide that, what it's about? Who gets to decide that? I mean, does the judge who's hearing the motion decide that this is not really about petitioning, it's about labor relations?
Yes.
And so it's a factual question.
It is, and the judge here,
A non-evidentiary hearing? It's going to go completely
Based
by
on the
what you think
record,
of the affidavit?
it's possible from the record here to determine that. The complete words of the email are before the court, and also the complete words of the Globe articles are before the court. A court can easily, any person can read that. This is not a legal determination, it's a factual determination. Now, I know Judge Young has suggested maybe the Seventh Amendment is involved in a different SLAPP suit in the federal courts, but here, you can read those 3 publications and determine that there's no mention of the petitioning, that it has to do with labor relations and patient care. It has to do with conditions in the workplace, and it's really quite a stretch to suggest that it's about petitioning.
Is this de novo review or an abuse of discretion?
It's abuse of discretion.
Abuse of discretion, I think that's
So if
Well-
the judge finds, we have the same record that the judge has. The
right,
judge says this is petitioning activity.
yes.
We have to defer to that.
Well, it's abuse of discretion review in this
Does
case.
that make sense? I mean, I know that's what our cases say, but does it make sense?
When we
think
have
so.
when it's on a paper record.
Well, that's what this is what this court has
I
said
understand, but
over
the
and
que- the
over.
question
So
is-
who am I to question that?
Justice Sullivan, in her concurrence, raises the question about the standard of review.
But I think she comes down on abuse of
That it
discretion.
doesn't make any difference here because of the nature of it, but because it's a question of, I think she says it's really a question of law.
I think, with respect, my memory may not be accurate, but
Well, of
what
course,
I
that's part of abuse of discretion, right? Or
I think
or
she
of
says,
law.
yes, it is. It was that the judge had not abused her discretion in determining that this was not petitioning. So-
I'm sorry. In your view, would the article have to have explicitly referenced DMH and the issues, the regulatory issues at DMH for it to be petition activity? It's not enough
think
that
it would-
the article talks in general about what's going on in the hospital and why they are compliant?
If you're talking about petitioning, what the cases say, the Globe, the newspaper cases specifically have been about mirror images of the petitioning. So yes, this is not even close to a mirror image, and it's not even about the petitioning. So the Steward here is looking to expand the anti-SLAPP law way beyond what this court has ever permitted. They are trying to squeeze random remarks into this mirror image doctrine where
Well,
the remarks don't
Justice
reflect...
Sullivan thought that it was a mirror image, at least the Globe part, right?
Well, she, as I recall Judge Sullivan's summary, she said something to the effect that this court, meaning the Supreme Judicial Court, had not really developed the mirror image doctrine. So she was going to piggyback on what the majority said, that somehow this was a mirror image. But in our brief at pages 31 to 34, we very carefully go through why this is not a mirror image of anything, certainly not of this Harshbarger report. The Harshbarger report is 3 single-spaced pages that starts out faulting the administrators at the top of the chain of Steward Hospital who allowed these things to happen. Mr. Walczak's statement says nothing about that. Mr. Harshbarger also talks about systemic failures in the management and supervision of the unit.
Ms. Radofsky, may I ask you, I'm really worried about a rule that would constrain a petitioner to announce or to say out loud what they're doing. And that's what I take from your comment about the email, that it says nothing about petitioning. It uses other words that no one would normally associate with petitioning. So how is a court, or how is a petitioner? The question was asked earlier about how is a plaintiff who sues to know what the statement means. Well, how is a defendant to know what he or she or it is supposed to do when they're petitioning? If you're saying that they have to use that word in whatever statement they make, I don't know how we could do that.
What the petitioners here, what the defendant, what Steward here is trying to do is to close the courtroom doors to these nurses who have been defamed in an employee email. It has nothing to do with petitioning. They're trying to say, because we're petitioning DMH over here, we can say about you these scurrilous remarks over here, and you have no recourse for those remarks that have ruined your reputations, made it impossible to find work. That's not petitioning. That is a separate matter. Now, if what Steward had done was said to its employees, we are engaged in a petition at the Department of Mental Health, and we're cooperating very strongly, and we want you all to know that, I would have no problem with that.
How about if they had said, because you're not protesting, I don't think, that the Harshbarger report itself is petitioning activity.
Not at this point. That's not part of the case
We're
anymore.
assuming that it is.
Yes, for these purposes, that's what the lower court found.
Right, and you're not
Are you
challenging
appealing
that
that just out
No,
of
we are
interest?
not.
You're not
No, we are
appealing it?
not.
Okay, so if they had said to the employees, pursuant to the Harshbarger report, that we have terminated all of these employees in service of our efforts to save our license, that would have been okay.
Yes, because that doesn't,
Thing happened in connection with the Boston Globe. Of course, it's a dicey situation with newspapers because you're not in control of what the newspaper reports.
that's correct. But if they had simply said, pursuant to the Harshbarger report, we have decided to terminate the entire staff, including the management, we wouldn't be here on a defamation claim. But to suggest and to insinuate, as Mr. Walczak did, that these particular nurses, that the nurses that he fired, had created safety hazards, and that only when he got the Harshbarger report did he understand that, and he had to fire everyone to prevent further damage to these vulnerable patients. Now, that is not what the Harshbarger report says.
What happened to the management, the supervisory nurses?
They also were terminated,
And they were put on administrative leave before, right?
as I understand it, yes. So my other 4 points, I'll jump to the point about fees, since I think we've exhausted several of the others. Steward here is suggesting that even if this court should make some sort of split decision and that the email is found to not be petitioning what the Globe is, for example, that they should be entitled to fees for partially prevailing. Now, that is without any support in this court's precedents. This court has said that the SLAP inquiry goes count by count, and no further subdivision is permitted. The two cases that have been proposed as saying otherwise really don't say that. In the California case, it is true there was titled a cause of action included 3 separate torts, and the court said, well, we could analyze these separately. But at the end of the day, the court there denied fees. There was no fee, even when there were 3 separate torts under one cause of action.
Because I didn't read it yet. On what basis did the court deny them?
Because the case was, because some of the speech, underlying speech, was petitioning and some was not. So they said,
So they took the position that you're taking.
yes, no fees, and it was an even more egregious situation. There was a defamation claim, an intentional interference claim, intentional infliction of emotional distress claim, and a third claim. And in the Massachusetts case, the Gifrito case that they cite, again, there was a single count against a single defendant in question. There were no fees awarded for a subdivision of a count.
Okay,
Thank you.
So you're telling me that there's one defamation count here
yes.
One count
with 2 allegations?
with allegations about 3 publications of essentially the same matter. And in our
So it's
brief,
two
we...
Globe articles and the emails, is that
Yes,
right?
and in our brief, I think it's footnote 18, we show that this is common practice, common pleading practice in Massachusetts defamation cases brought involving the anti-SLAPP, that there are 5 or 6 different cases where defamation includes several publications of the same matter in one count, and that count either rises or falls, and the SLAPP analysis is for the count as a whole.
So it's the count because the count reflects a cause of action
Yes,
against the same party
yes.
or parties.
Well, if the parties say different things in different places, you may have different counts. But here, we have one speaker making essentially the same statement in 3 different places.
Yes,
And so it's a unified pleading in one count, which is the way the Massachusetts pleading rules are conventionally understood and have been understood in the SLAPP context.
because you could have different counts for the same cause of action against different parties.
You could, yes.
Okay.
But that's not the case
But,
here.
okay, so you certainly make that argument about the fees. You also make it otherwise. So just to, put the fees aside for a second, because I think part of your argument is, as long as any piece of this single count for defamation doesn't qualify, I mean, let's just assume for the minute, hypothetically, that you would agree that the Globe pieces are petitioning activity. But isn't your argument that because the email is not, the whole claim would go to the jury on defamation? That's what I'm trying to figure out.
The claim would go to the jury. The evidence would differ based on what the analysis was.
You would be entitled to put in evidence about the Globe in support of your
I
defamation?
think that would be for the trial judge to decide. I think if it was, there might be some further chopping, that we might say, well, we'll only talk about this sentence, which is not anywhere in any petition. But in any case, the defense that Steward would have to that defamation claim would be the same defense it would have if all the publications
But
were
it's
in
not
there.
that simple. I mean, it's very difficult to try and figure out juries. But getting the Globe out and keeping the emails in is a case where the vulnerability of damages is dramatically different.
The damages would be different. I agree with that, Your Honor. But for the anti-SLAPP analysis, it makes no difference. There should be no fees. There's no dismissal of the defamation claim.
Okay, thank you.
Thank you.